Okay, welcome everyone to CBIA's HR Hotline Live. We're talking again about Connecticut's new paid sick leave law. We did this in September, and we've got a little more information now. We've been working with these wonderful partners from Carmody, Torrance, Sandak, and Hennessy, Nick Zaino, and Vincent Farisello, and we've also been working with the Labor Department to kind of try and nail down some of the details on this new statute. So we've got some updated information. If by any chance we give you different information today than we gave you in September, today has the updated information. So today's information is correct. So this is a Q&A. We're not going to have any slides. This is all about your questions. I'm going to start out just with some very basic information. I know a lot of you have already submitted questions, so we thank you for that, and we will handle those first. First, I'm Diane Mokriski. I'm HR counsel here at CBIA. Nick Zaino and Vincent Farisello are both partners and who practice in employment law at Carmody, Torrance, Sandak, and Hennessy. Hi, Nick. Hi, Vince. Thanks for joining me again.
Thanks for having us.
So we're going to talk paid sick leave. If you could put your questions in the Q&A instead of the chat, that would be great. So we only have to check one place. And so for those employers who already were covered by paid sick leave, those were employers who had 50 or more workers, and manufacturers were exempt. You may know that the law recently changed, and that change goes into effect on January 1st, 2025. So on that date, almost all employers with 25 or more workers are covered. There are very few exceptions to that. The only exempt employers are really those subject to a very specific type of collective bargaining agreement, which we'll cover a little bit later. So the basics are that all workers accrue paid sick leave. They get 1 hour of paid sick leave for every 30 hours that they work. It doesn't matter if they're full-time or part-time. You count the hours that they worked. Once they've worked 30, they get an hour of paid sick leave. Time starts accruing on January 1st, 2025. Okay, those are the very basics. Now I want to just start, we've got some very common questions that we get all the time. And one of those common questions has to do with carryover. So Nick and Vincent, can you explain the rules about carryover? If you get 40 in a year, how does the carryover work, and how does front loading impact carryover?
Sure, I'll jump on that. So for the employees who accrue their time at a minimum of 1 hour for every 30 hours worked, as you just outlined, they're entitled to carry over up to 40 hours of that accrued time from that year. They're allowed to accrue up to 40 of those hours that were unused into the following year. And there can't be any restrictions on when they can use that carried over time in the new year. So some employers had policies that says when you carry over, you need to use it by the end of the first quarter or by some other date. You can't do that anymore. The carried over time can be used for the entirety of the following year in which it's carried over. The exception to that general rule is if you're an employer out there who chooses to front load the paid sick leave, because the statute does allow for employers to comply by front loading in lieu of accruing the time. So if you front load up to 40 hours, then at the end of the year, if there are unused hours, the employee does not have the entitlement to carry over the unused time. Now I'm going to go back for a second to the carryover. Let's say employer does do the accrual, must allow for carryover. The employer can still limit the use of paid sick leave in that following year to 40 hours used. So even though an employee may have carried over some time and accrued more time and may have more than 40 hours in the bank, the employer can still choose to limit use in that second year to 40 hours.
Okay, so let's say it's the year 2025, and at the end of the year, I am an employee and I didn't use any of my time. So I've got 40 on December 31st. I can carry over all the 40 until the next year. and then I'm still going to keep accruing, right? So by the end of the next year, in theory, I could have 80, but I can only use 40, right?
Correct.
Yes.
Okay. So, and do you agree, like the theory behind that front loading rule is that the labor department wants people to be able to use their sick leave at the start of the year, right? So a lot of people say, like, what's the point? If you could only use 40, what's the point of carrying it over? And the point is that if you carry it over, you can use it right away, as opposed to accruing it little by little.
Exactly. That's right.
Okay.
Yes.
Nick, do you want to tackle mental health wellness? I think
Sure.
last time you and I talked about this, we were thinking maybe you could only use it as a full day. And we've got
Yeah,
to update it.
this is one of these where the DOL provided some guidance, and basically one of the reasons that an employee can take paid sick leave is for mental health wellness, and it's a very broad term. It can be taken in 1 hour increments, just like all the other reasons for paid sick leave. And there's no limitation other than the 40 hours on the number of mental health wellness days that somebody can use paid sick leave. So, that's the DOL's position on that. It can be used in 1 hour increments, and there's not a limit on the number of days in which somebody can use mental health wellness.
Okay. So mental health wellness is just like it's just mental health. It's another reason to take paid sick leave, right? So,
Exactly. Yeah.
okay, let's cover doctor's notes. Vincent, what's the rule on that?
So I'm going to go back to what the old rule under the existing statute specifically allowed for employers to request doctor's notes or other documentation after an employee used sick leave in 3 consecutive work days. This new statute specifically removes that ability for employers. So to say it as basically as I can, for the 40 hours of sick leave that folks are entitled to under the statute, employers cannot ask for documentation when employees use sick leave. That's allowed under the statute.
Okay. So for all those employers that have that rule that if you're out 3 days or more, it's time for a doctor's note, you may not do that anymore if it's within these 40 hours that are covered by paid sick leave. Okay.
If I can piggyback on it for 1 sec, Diane, if
Yeah.
you're an employee, all employers, of course, are allowed to provide more than can allow their employees to use more than 40 hours of sick time in a year. And so the DOL has been pretty clear that if you allow more than 40 hours for any of the hours beyond the 40 that's required under the statute, anything beyond that, the employer has much more leeway. They can ask for doctor's notes for paid sick leave used in excess of 40 in a year.
Okay. And then, Nick, let's talk about this will be the last thing we talk about before we go to the specific questions. Advance notice of the need for leave. What's the rule on that?
Yeah, so the Department of Labor has taken the position that employees are not required to provide any advance notice of the need to take sick leave under the statute. So an employee could call in that morning and advise their employer, I'm not coming in today, don't feel well. There's no advance notice requirement, even for the DOL's position, even for things that are foreseeable. So somebody may have a scheduled doctor's appointment and fail to give you advance notice of that until maybe the day of, saying, I can't come in today, I have a doctor's appointment. And so, the DOL encourages and states that employers can have a policy where they request employees to provide advance notice. But if an employee fails to do so, they couldn't take disciplinary action against the employee for failing to give advance notice. Now, that's one of those areas where, different minds can read the statute differently, but, certainly the DOL is entitled to deference as the agency that interprets the statute, and that's their position on the advance notice requirement.
All right. And so is it your understanding that that also applies to points? So that, if you don't give notice that you need to be absent, the employer cannot give you a point There can be no disciplinary action whatsoever.
Correct. Yeah. Basically, those 40 hours, as long as the employee is taking it for a covered reason, you can't take any disciplinary action against that employee for taking that time, including failing to provide notice. So.
Okay. All right. I'm going to go to the questions, some of the questions that were submitted in advance. Okay. The first one is, if an employee used the 40 hours of sick time, but they still continue to call out sick, can we then require a doctor's note? And if they don't provide it, can we give them discipline?
Yeah, I think this is kind of similar to the point I was making a few minutes ago, Diane, that after an employee exhausts the 40 hours to which they're entitled under the statute, if they continue to use sick time, and the employer can choose to have a policy to require doctor's notes after that 40 hours. And if the employer does initiate some progressive discipline or something like that, they would not, in that case, be running afoul of at least the paid sick leave law.
Okay. The second question has to do with counting to 120. So let's just talk about that for a bit. There are 2 times you have to count to 120. The question came in about, I think just when you're allowed to use the hours that you've accrued. So Nick, do you want to cover the 120 calendar day rule first?
Yes. So as Diane mentioned at the outset, the paid sick leave law goes into effect January 1st of 2025 for all employers that have 25 or more employees. So that means that your existing employees start accruing at the rate of 1 hour for every 30 hours worked, effective January 1, or if they're hired, if you have a new employee hired after January 1, they start accruing on the date of hire. Newly hired employees cannot use their sick time, even though they start accruing on Jan 1 or after their date of hire, after Jan 1. They can't start using until they've been employed for 120 days or more. Existing employees who have already been employed for 120 days, they can start using their accrued time right away because they've already met that one-time requirement that they be employed for 120 days. So that's the date on which an employee can begin to use their accrued sick time, 120 days after they're employed.
Okay. So that's 120 calendar days. So now, Vince, let's talk about when's the other time you count to 120?
Yeah.
So the statute excludes what the statute defines as seasonal employees from coverage under the statute. And it defines seasonal employees as any employee who works 120 days or less in any year. So an employer would be able to exclude from coverage under this statute an employee who may have been on the payroll for more than 120 days, but does not work 120 days. So 120 days worked in any given year.
Okay, so how do you figure out if you got a college kid that's coming in just during school breaks, and you expect them to keep coming back? They came in spring break, and they're coming back in the summer, and they're going to come back in Christmas. How do you figure out when they get paid sick leave?
So you look at each year, whether you're using some different benefit year or calendar year, and you count how many days they came into work. And doesn't need to have been for 8 hours or 6 hours or whatever. It's just any day that they came into that they worked. That counts as a day for calculation of the 120 days worked in that year.
All right, so the 120 work days, so everyone understands, that's only for people that you think are temporary, seasonal. The statute says seasonal.
Right.
It really means it could mean per diem. It could mean temporary, like consulting work if they're employees, right? It's really anyone who may not be long-term, right? You're counting work days.
Right.
One thing about that, we can talk a little bit about tracking and how the employer has this obligation to track time. This is really tricky when you're counting to 120 in 2 different ways. So if you've got a seasonal worker, you really got to keep track of how many days they work, and you don't have to until they reach their 121st day, they're not even really considered an employee under this statute. And so you don't have to provide them information about how they're accruing, right? But as soon as they hit their 121st day of work, all the hours that they accrued for the past 120 days is paid sick leave that they're entitled to. Right, so it's really important for an employer to, even if you think this person's not going to work more than 120 days, you should really keep track of how many days that they're working. Okay. So here's a question. If we offer 56 hours of PTO in the first year, and someone uses 40 hours of that for vacation, so there's 16 hours left, do we comply with the policy? And that's kind of strangely worded. Can you explain how can they comply with the law if they gave 56 and the first 40 somebody blew it on vacation? What's the remaining 16? What's the rule?
Yes, I mean, as long as your PTO policy is fully compliant with the paid sick leave law, in other words, you allow employees to use at least 40 hours of accrued PTO for all the sick leave purposes and all the other manners that the law requires, like 1 hour increments. If an employee chooses to use 40 of those hours, 40 of those 56 hours of PTO that they've accrued for vacation purposes, leaving only 16 PTO hours left, then that's okay. Like, you've done your part because you have offered the employee the ability to use PTO for at least 40 hours for all the reasons covered under the Connecticut paid sick leave law. So the key is to ensure that your PTO policy is revised and compliant with the sick leave law.
Yeah, and one thing that the Labor Department attorneys emphasized with that, which I thought was interesting, is that if those first 40 were used for vacation, the 16 that remain, they can be used for sick, but you have to follow all the restrictions about those 16 hours. You can't require a doctor's note. You can't require advance notice, right?
Correct. Yes.
Okay. What type of reports is the state going to require for proof of the sick time policy being followed, especially if everything is grouped under one PTO bank?
So I'm not sure there's a specific type of report or document that the state is going to put together and require employers to use. The advice I've been giving is obviously have your policy in writing, be able to show your policy, to be able to show that to the state as evidence that you're meeting the minimum obligations under the statute. And the statute does require that you track the number of hours that employees accrue or are provided, and the hours that they use. And so, I think the easiest answer would be to be able to provide the state evidence of what those accruals are and employees' use. It'll most likely be done using your regular payroll software.
Yeah, and so if you just give all your employees 40 hours of PTO and you don't care how they use it, it could be sick or vacation. You don't have to, on your software anywhere or in your books, you don't have to distinguish, you don't have to write down the reason why the people are absent or keep track of the reason why they're absent, because it's all the same. If that's your policy, you gave 40 hours, so you're not keeping track of whether it's sick or vacation, it's just any reason. So then you don't have to really track it. You don't have to track the reason. You just have to track that you gave 40 hours and it's gradually being used.
Right.
And I think that's right. It would be important for employers to have a policy that explains all this to their workers. So if the Labor Department comes in, you can show them the policy and you show them your payroll system showing how you're keeping track of the hours.
I'm just going to jump in for 1 second, Diane. I just think I think it shows just how important it is to look at your policy right now before January 1 and amend it, revise it if it's necessary, But now more than ever, it's important to make sure it's accurate and that you're getting everything you want in there. And if you're an employer out there who wants to treat time used beyond 40 a little bit differently, or you want to put some more guardrails on that, that's your opportunity to do it in your policy.
Okay. There's a question about how to handle CT, FMLA, and short-term disability. Do you want to talk about that briefly? I mean, how would that happen in real life if someone has something that would, let's say that it would qualify for all three? What would the employer do?
Yeah, so I think if you have a situation where an employee is going to be out of work for a reason that may be considered a serious health condition or may qualify for leave under the Connecticut or Federal Family and Medical Leave Act, you as an employer have a right under those laws to require a medical certification form from a healthcare provider for purposes of determining whether or not that leave is covered under the FMLA. And if it is, to designate it as such and begin tracking it. So if someone is using time off just for sick leave purposes and there's no indication that it's a serious health condition, there's no indication that it would be for an FMLA purpose, then no, you cannot require medical documentation. But you can continue to administer and should continue to administer your obligations under the Family and Medical Leave Acts as they apply to you. As far as your short-term disability policy, that is entirely optional on the employee's part as to whether or not they want to apply for short-term disability benefits. And if they choose to apply for STD or later LTD, they're going to have to provide the documents that are required under those various benefit plans in order to qualify for those benefits. And so they don't need to provide it to take paid sick leave, but if they want to qualify for STD or LTD, then yes, they need to follow the process under those plan rules.
Okay, let's talk about holiday pay. That's coming up with Christmas. Christmas is on a Wednesday. A lot of people have a rule that says you have to work on the day before or the day after a holiday in order to get holiday pay. Vince, you want to tackle that one?
Yeah, so it's a pretty common policy out there, and my understanding for it, it's not directly addressed in the statute, but we've gotten some guidance from the Department of Labor. I know you've talked at length with them about this, Diane. My understanding of their position on it is that if an employer can have a policy, as long as it's applicable to all employees, that requires employees to work the day before and the day after. Again, and I think if I'm just going to give an example, if an employer had a policy that said anyone who's taking paid leave before or and after the holiday would not be eligible for pay for the holiday, that would be okay as long as they're not treating the folks who are taking the PSL worse or differently. If it's being applied equally across the board, that would be okay. What would not be okay from the DOL's perspective, though, is if you tried to have a rule that said if you're taking paid sick time before or after, we need a note in order to excuse it to allow you to be eligible for the holiday pay. That they would not be okay with.
Okay. Let's go to some Q&As. A lot. I'd like to understand how we can verify if an employee is out for their own health reason or for another reason. The reason I ask is that we acquire, okay. Oh, okay. So let's talk about fitness for duty notes and how much information you can ask of an employee when they call out sick.
So when they call out sick, not much. The only thing you can ask is whether or not it's for a covered reason under the paid sick leave law. And if the employee says it is for a covered reason under the paid sick leave law, then you would have to, as long as they've accrued the hours, you'd have to give them that time under the sick leave law. They can't provide zero information. So if they call in and they say, I'm not coming to work today, and you say, why is that? And they said it's for personal reasons, and they don't tell you whether or not it's for a covered sick leave or they're meeting a contractor to get something fixed in their house. They just tell you it's for personal reasons and they're not going to tell you. Then you should not count that as sick leave. You should count that against any other paid time off that may be applicable or unexcused time off. They haven't given you a reason that would be covered under the paid sick leave law. As far as fitness for duty, so this has come up a lot. And, the DOL's position, which I think makes sense, is you can ask for a fitness for duty certification when you're legally permitted to do so under a law like the Family and Medical Leave Act or the Americans with Disabilities Act, or you're required to do so under some law, federal or state law. But you shouldn't make that a routine requirement every time somebody uses a single day or hour of paid sick leave. Otherwise, it sounds like you're requiring the fitness for duty as sort of a way to get a medical note to justify the sick leave, right? So if you have an independent reason for requiring a fitness for duty that is valid, it's justified, somebody has been out, they've had a contagious illness, you work with a vulnerable population, and you want to require that employee to provide you a note so that there's not a workplace safety issue for them or your clients, then yes, that makes sense perhaps under the ADA to provide a safe workplace, or just generally to provide a safe workplace, but not as a routine. I would not advise doing that all the time for every time somebody takes sick leave for every possible reason.
Okay, let's talk about, this is going to require some concentration. Let's talk about salaried exempt workers. Okay, so exempt employees don't fill out timesheets. This particular company doesn't have people use PTO by the hour, only by full days off. So how does a company comply with having people be exempt and also comply with the paid sick leave law?
So I think there's two different things going on there. One is the accrual, right? How do we accrue? So the statute does allow for those exempt employees whose regular work schedule is 40 hours or more per week. The statute allows employers to assume that the employee worked 40 hours for purposes of the accrual. So you don't need to necessarily track for full-time exempt employees just for purposes of the accrual. Little different rule though if you have full-time exempt or any exempt employee whose regular schedule is less than 40 hours. In that case, you will have to track because the statute does require you to provide the 1 hour for every 30 hours worked and to track it. So, but if their regular schedule is 40 or more per week, you can just use the 40 hours per week as part of the accrual calculation. Of course, you can avoid it altogether too by front loading. So that's the first part, I think, of the response. The second part is the use. If your policy currently for exempt employees is that they can only use the PTO and you're using your PTO to comply for PSL purposes, they can only use it in full day increments, that would violate the law. You do need to allow them to use it in minimum 1 hour increments. So
Okay.
there likely will be some changes that need to be made for that employer.
Okay. Are employers required to sorry, it moved on me there. Are employers required to distribute the poster separately to each employee, or will the new PTO policy being included in the handbook fulfill this requirement?
I could jump on that because the statute does require that employees receive certain information from their employers about PSL, including, their rights and responsibilities under the PSL, information about non-retaliation, where they can file a complaint, but also the basics, how it's accrued, what it can be used for, et cetera, et cetera. The statute then says employers must comply with that in two ways. One is by posting the notice in a place that most employees would have access to it. For remote employees, it can be sent to them electronically. But in addition to that, you also have to provide written notice to employees, separate from the posting obligation for the poster. And that notice requirement can be satisfied by distribution of a policy, if you choose to do that, or by some other method. But it's not a one or the other. It's kind of a both. It's not kind of a both. It is a both. The statute uses the word and.
Yeah, so CBIA could post the link to the Labor Department site. If you go to that site, there are lots of things there. There's a poster, the poster for you to post in the common area. There's a prototype notice that you can send out. But if you have a policy that's a little bit different than the prototype notice, you want to email out your policy. And then there are also other things on that link. You can watch a webinar that the Labor Department attorneys gave. They also have PowerPoint slides that you can look at, and they have Q&As that you can look at as well. The next question is, if we currently offer vacation time, can we rename that to PTO in order to be in compliance? The answer to that is yes, as long as you can use that for paid sick time. Is it 40 hours plus a mental health day? I'm just going to answer that. No, it's not. Mental health is part of the 40 hours total. All right. If we give people a pool of time at the beginning of the year so that we don't have to deal with the sick leave carryover, can we just give them 5 days up front and say the rest is accrued?
Yeah, you can do that as long as you give, it's really 40 hours up front, not necessarily 5 days. So you can give 40 hours up front and say you can use it for all the various sick leave purposes. And then in addition to that, you can do an accrual of time throughout the year.
Okay.
As long as those 5 days are available up front each year for use for paid sick leave purposes, then there's no need to do the carryover. So you could just do 5 days, period, just 5 days of PTO, and you can use it for all the sick leave purposes or for other personal reasons. And it's available each year, not 5 days, 40 hours each year up front, then there's no carryover requirement.
All right, now I'm at 1:05 p.m. We currently front load at the beginning of each year, PTO, that covers timeout. PTO requests are made through the payroll system. We currently have a field that asks for a reason. Should we remove that reason field? I was just talking to the Labor Department attorneys about that this morning, and they said that you can still retain that reason field. You can require your employees to fill that out as long as you just have them say paid sick leave, as opposed to vacation or something like that. You can't require them to say, hysterectomy or something like that. It's just got to be like sick days. That's what you can make them say in the reason field. Let's do 1:08 p.m. What if someone starts in the middle of the year, like June? Do they have from that June until the following June to use the 40 hours?
It sort of depends on, what the employer has decided on for the year in which they administer paid sick leave, whether they're doing calendar year or whether it's a fiscal year or some other benefit year. So it really does depend on that. So just assuming that the employee starts in the middle of whatever the employer's benefit year is, if the employee is accruing the time or it's being front loaded, they can use it for the remainder of that year, and all the other rules we've talked about continue. If at the end of that benefit year, if the employee had accrued time, they get to carry over up to 40 hours unused. If the employer is doing front loading, the carryover doesn't have to happen at the next benefit year. But it really, I think it just totally depends on what the employer's selected benefit year is.
Here's something a little awkward that happens in the year 2025 with that. So let's talk about that briefly. So let's say you're using a fiscal year for your benefit year, and let's say it starts July 1, and everyone gets a new batch of PTO on July 1. For this first year, January 2025, it doesn't matter if you're using fiscal year, anniversary date, or whatever. On January 1st, 2025, you have to let your employees begin to accrue paid sick leave little by little, an hour for every 30 hours worked. And so that's going to be a little annoying in the year 2025. But the way you would handle that is from January through June, you let those employees accrue little by little because it's required. But as soon as you hit your whatever date you want to use, let's say it's July 1, just start again. Give them either let them start accruing or front load whatever amount you want to front load. Whatever they haven't used can fall away. And it may be that in the year 2025, some employees will get more PTO than they would otherwise get because maybe they used a little bit until you got to that fiscal year start, but that that will only happen in the year 2025.
Yeah, that's exactly right.
So let's go to 108. If the employee uses their 40 hours of sick and accrues more time during the year, another several weeks, and at the end of the year, they have 40 hours left, and they roll it over to the new year, why can't the employer have them use that by a certain date?
It's just what the law just requires you to allow them to carry it over in the current benefit year to the next benefit year. And they can use, but you can still cap the total usage at 40 hours for sick leave. So you just can't say you've got to use it, the carried over amount by X date. You can't dictate to the employee when they must use their sick leave. If they're entitled to use the sick leave at any time throughout the year. You can cap it at 40 hours, however.
I wonder though, for this particular one, so the employee used their 40 hours of sick. Let's say it's the year 2025. The employee used all 40 hours.
Right.
So there's really nothing to carry over, really.
Right, at least not from a statutory standpoint.
Right.
I
So
think
in that scenario, this is Kathy, I think. In that, right? I think this was Kathy. Yeah.
yes.
Well, in that scenario, that's the employer voluntarily letting them carry
Right.
over hours.
The excess out, yeah.
And so, Kathy, I hope you understand that. So in that scenario, you could require them to use the carried over hours by a certain date because they're giving more carryover hours than what the statute requires.
Right.
Yeah, okay. Can sick pay be part of vacation time? Yes. Okay. Okay, we just did calendar year and fiscal year. How about safety sensitive positions? I do not know. Jessica, you can call me and ask me what you mean by that. Safety sensitive positions aren't any different. I wonder if you mean that, I'm not going to try and guess on that. Give me a call on that. Let's do 1:09 p.m. For the sick tracking. Our company has PTO. Does my system have to show how many hours of sick time they have left or just the total PTO accrued hours? Is that fine? Can we keep a separate log of sick use to share with the team members? That last part is something to deal with separately, but which one of you would like to answer that?
I think we talked about this before,
Yeah.
that this kind of has to do with the record keeping that you're supposed to do under the statute. And if you're doing a combined PTO bucket, you can satisfy it by just showing what PTO was provided, accrued or front loaded, whatever it is, how it's being provided, and when and how it was being used. I do know there are some employers out there who are applying some, trying to, within a single bucket PTO, trying to track when that PTO is used for different reasons, for purposes of, say, documentation or advance notice or whatnot. I don't know that the statute would require that to be part of the record retention obligation under the statute, but the employer will, who's trying to treat things differently a little bit within that single bucket, will necessarily have to kind of be tracking it that way.
Yeah. Yeah, you may decide to do that. If you kind of go back to the situation we just talked about with, I think it was Kathy or something, where you allow a significant amount of PTO and somebody has used all 40 hours of that PTO for sick time, and we're talking about the carryover. The only way you're going to be able to restrict the use of the carried over time in the following year is if you are able to show that they did in fact use 40 hours of that PTO for sick leave purposes, right? So there was an assumption in that question that they exhausted it. The only way you're going to be able to then limit the carried over time in the subsequent year, say to the first quarter, or you've got to use it, within 6 months or whatever, is if you're able to show that carried over time is not sick time. It's additional
Hmm.
time that the employer provided. So it just depends on, how vigorous you want to enforce your PTO policy strictly against the sick leave law.
Okay, if we pay out unused PTO at year end, do we still have to carry over sick time?
So we could kind of split hairs here a little bit, but I'm going to start with the general proposition that for PSL purpose, for PSL, paid sick leave, an employer can offer to pay out unused paid sick time at the end of the year rather than in lieu of carryover. But that would require the employee's agreement to that. The employer can't just mandate that and force it. Because if you think about it from a theoretical perspective, that would go against the DOL's or the public policy of having the time available for folks in the beginning of the year. So mandating the payout wouldn't be okay. A little bit of a funky wrinkle when we're talking about PTO, because I might ask, well, if you're keeping track of when the PTO is used for PSL purposes, and they've already used 40, then maybe you can force payout of the PTO at the end of the year. But I think that that's a little tricky and risky to do. And so I don't know if you think differently about that, Diane or Nick.
I think it's the same answer as the other one. Like if you can show, let's assume you have PTO, but you have a separate designation of PTO-S, and you can show that they accrued, this PTO, they used
And they used it
40
all.
hours. Yeah, I think you can do whatever you want with the remaining PTO. But again, that requires you to track, like it sort of defeats the purpose in many ways of a PTO system, which is to avoid all that. But if that's how you want to manage your PTO system, you want to manage it strictly and say, for any hours above what the sick leave law requires, we're gonna pay it out at the end of the year. Then you have to have a good tracking mechanism to show that you allowed employees to use at least 40 hours.
Okay, for the safety sensitive position, she was talking about fit for duty physicals. So that those are not prohibited by the statute. So if you think you need a fit for duty physical because someone was injured, then the Labor Department will not have a problem with that as it pertains to this statute. Is that fair? Do you guys agree with that?
I agree. I mean, if somebody
articulate that in a really specific way.
I mean, if somebody takes a mental health wellness day, right, and you say, I want to fit for duty before you come back, that's not going to fly, right?
They won't be happy with that.
Right.
I had something. How about 136? And benefit year for each employee be hire date? Yes. Okay, 135. If an employee chooses to use 1 hour of time to cover a shift, so they're scheduled for 7 hours, but they only ask for 1 hour of time to be used, is that entire shift covered by the law?
I think what they're saying, I'm just going to guess what the question is, and we could answer that. If someone's taking the whole shift off for a sick leave purpose, can the employee just say, of this shift that I'm missing for this paid sick leave purpose, can I only apply one of my hours of sick leave for that shift? I think that's what the question is. In other words, the employee's trying to save their PSL for some other date. If they've told you they're missing the shift for a PSL purpose, the employer, you're within your right to apply the whatever hours they have to the full shift if they have enough hours to cover it.
Okay. How about at 128? This applies to religious entities, including churches and schools. Yes. How about 133? Can you auto apply sick leave if you know it's for an eligible reason, even if the employee doesn't ask or want to use it?
I think it's similar to the last answer. If you have reason to believe, if they have told you that it's for a PSL qualifying reason, then yes, you can apply it.
I agree.
Yeah, and if they won't, I mean, yeah. If they won't say why they're gonna be out, then that becomes a unexcused absence.
Right.
Exactly.
You might not apply the PSL, but now
Right.
it's not protected.
Right.
Okay. Okay, I'm at 134. Can you please briefly address the requirements and notices for employers with 10 or fewer? 10 or fewer. That's
I'll think right now.
2026, right?
Yeah.
It's 11 or fewer though, right?
It's 11 or more.
11 or more, right?
Yeah, as of 1/1/26. So you can sit tight. There's no notice requirement at the moment.
So
For a
10 or
while.
fewer, that's going to be 2027, right? Am I
I'm
right?
sorry. Yeah,
25?
yes.
Yeah, so if you're
Yeah,
10 or
25,
fewer,
11, 1. It goes 25, 11 or more, and then 1 or more. So
yep.
25 as of 1/1/25, 11 or more as of 1/1/26, 1 or more as of 1/1/27.
So for this question at 134, you have no notice requirements right now. You do not have to worry about this law at all. You don't have to put up any posters, send out any notices until the law applies to you in 2027. Okay, how about I'm at 135. To get an accurate count, if you have 25 employees, do you count those employees who are seasonal or who haven't yet worked 120 days? And is this for the payroll that includes January 1?
One thing that dawned on me, Diane, you made the point before when the definition of employee excludes seasonal employees, right?
Mm-hmm.
I'm thinking this through. Like I hadn't thought about that question
Yeah.
before, so I'm trying to find where in the statute it says the counting of employees.
So what I remember about the counting is that they only will count on January 1st. And that came up a lot because people use seasonal employees over the Christmas holidays and then they lay them off at the end of December. If you lay them off in December and you have fewer than 25 employees on January 1st, you are not covered by the law, as long as you didn't intentionally do that to avoid coverage.
Right. But yes, and it's funny when you're looking at the counting employees, they don't say employs 25 or more employees in the state. It's 25 or more individuals in the state.
Right.
So you do count if they're still on your payroll. If they're still employed by you on the applicable January 1, you do count them for purposes of coverage, for employer coverage.
Yeah. And I think I must have scrolled by this, but I did see a question about employees who don't work in Connecticut. I think that was Teresa's question. Teresa, I'm sorry if I blew by you. Can you guys explain? There we go. 126. Oh, no, that was a different one. Pretty sure Teresa asked earlier, if you've got workers in other states, how do you handle that?
Yeah, they're not covered or counted toward the 25. So the 25 is 25 or more individuals in the state, and a covered employee is somebody who is working in the state. So if you have a remote employee working outside of Connecticut, they're not a covered employee and not counted for purposes of the 25 employee threshold, individual threshold.
Yeah, and the Labor Department relies really heavily on the unemployment, like the way they define Connecticut employees is simply whether you are declaring them, you're using them for the purposes of unemployment in Connecticut. I had an interesting issue come up several times, a question about actually the definition of employer, where a person owns several companies, and each company has 20 workers. And whether, the statute says that an employer is a person, or I think it might say a person or an entity with 25 or more employees. But the Labor Department attorneys told me that they are going to consider the employer to be the entity with the EIN number. And so if you are an individual who owns multiple companies with fewer than 25 workers, you are not an employer. The employer is the company with the EIN number. So there you have that.
No.
So at 149, if we've got a part-time employee working 20 hours a week, how many sick time hours are they eligible for? every time they work 30 hours, they get an hour of paid sick leave.
So I always say with the part-time folks, and if you had a policy that just says we give it to you on a prorated basis, for example, if you're doing front loading, you have to be careful about that because you have to make sure whatever you front load to them will be no less than what they would have received if you had accrued 1 hour for every 30 hours that they worked. So if someone works 20 hours per week for an entire year and you just give them 20 hours of PSL, you will likely violate the statute because that will be less than what they would have gotten by accruing 1 hour for every 30 hours worked.
All right, at 150, can a company allow employees to use their paid sick leave before they fulfill the 120-day requirement?
Yes.
Yeah, you can always be more generous than what the law requires.
Some of these are repetitive, so if you're wondering why I'm skipping you, it's because we've already I'm just laughing at someone who said, I'm sure you already covered this. Okay, how about at 141? If we allow employees to use their 40 hours for anything, and our code in the system states personal leave, which is used for vacation or sick, should we add a sick day code in addition to a personal day code? This is talking about tracking when you have to distinguish between vacation and sick. I think we kind of covered that. I'll keep looking through questions if you want to, if there's anything you want to add about that, either of you?
No, I think just to reiterate, I think the same point that to the extent you want to make distinctions within your PTO policy between PTO that is used for sick leave purposes and PTO that is used for non-sick leave purposes. So if you want to be more aggressive in limiting how PTO that is being used for a non-sick leave related purpose, you want to be more aggressive in how you allow employees to use that time, then yeah, you're going to have to track. You're going to have to be able to show that, they were still allowed to use 40 hours of PTO for sick leave purposes. We're talking about the excess. If, however, you open up your entire paid time off policy and say you can use the entire bucket of PTO for sick leave, you can use 2 weeks, you can use 4 weeks of PTO for all sick leave purposes, all the way up to 4 weeks, then there's no need to track, in my mind, whether it's sick leave or non-sick leave. The entire 4 weeks of PTO can be used for sick leave. So if you want to draw distinctions within your PTO policy and be more strict on the stuff that exceeds the time off that exceeds the 40 hours, then yeah, I think you should track.
Can we just go back to there's a follow-up question, Vince, about salary exempt people. Should we have the exempt employees fill out timesheets now? So now we're tracking hours. Doesn't that defeat the point of exempt people? Can you just talk a little bit about like why employers now might be tracking anything having to do with exempt workers?
Yeah, so the statute allows that if you have an exempt employee whose regular schedule is 40 hours or more, even if they work more than that, even if sometimes they work a little less, but generally their schedule is 40 hours or more, then you can, for purposes of that accrual that we must do, you can just assume it's 40. In that case, there would be no time tracking that's required. You wouldn't have to keep track of hours worked. It comes into play for exempt employees whose regular schedule is less than 40 hours, because for those folks, this statute says if you're doing accrual for them, then you need to count the hours you need to do the 1 hour for every 30 hours worked. That's when it would come into play that's when tracking hours worked would come into play for exempt employees. And doing that would be for no other purpose than complying with PSL. Nick, looks like you were going to say something.
No, I mean, just to kind of put a little more, just to track the statute, it says basically that an employee who is exempt from overtime is presumed to work 40 hours each week, except that such employee whose normal work week is less than 40 hours shall accrue based upon the hours worked in such normal work week. So you presume it's 40 hours unless you can show that it's less than 40 And if you want to track more strictly because they work less than 40 hours, you want to track, because they work 30 hours a week, right? You can do that, but in order to do that, you're going to have to track the number of hours that they work. So you might decide for your exempt employees that's maybe more hassle than it's worth, and you just simply go with the presumption of 40 hours a week, so that each week they accrue, one, and then they have 10 hours to kind of, for the next week. And so over, you know what I mean? So unless you want to, for exempt employees, be very strict, if they work less than 40, which you can, you're going to have to track those hours then.
And I guess, so you guys were talking about tracking the hours worked, and now the employers are tracking their use of paid sick leave. So that is something that you're tracking.
Yeah.
I don't know that that's necessarily new. I feel like most employers track how much PTO people have and use. So that's maybe not necessarily new. One question that came in advance that I skipped over unintentionally had to do with increments of time. You know how normally an employee can use paid sick leave in increments of 1 hour or more. If an employee shows up to work half an hour late, I actually spoke to the Labor Department about this today. So if an employee shows up half an hour late, the employer has two choices. You can either let that employee use half an hour, and the employee says they're sick. Okay, they were feeling sick that morning, so they're half an hour late, but they don't have to give any notice, remember? So they just showed up half an hour late. So in that scenario, the employer can say, I will let you use half an hour of paid sick leave, even though normally you would only have to use it in an increment of 1 hour or more. The employer can say, I will let you use half an hour because you're half an hour late. The other alternative would be for the employer to tell the employee they cannot clock in until they're an hour late. And at that point, they will use an hour of paid sick leave. So,
or is there or discipline the employee for showing up a half hour late?
That's what we were talking about. You cannot discipline them.
That's fascinating.
Interesting. Don't think I don't imagine many employers are going to say, okay, sit there, don't be useful, don't clock in. I just want to sit there and watch you suffer and not work. You're like, who does that benefit? That doesn't benefit anybody. But you can't discipline them because there was under the law, you are not required to make them give you notice. So you either give them the amount of paid sick leave that they actually used, which might be less than an hour, or you make them use an hour, but don't let them clock in until they've been an hour late, or leave an hour early, whatever the case may be. Thought that was kind of interesting. So we have 1 more minute. I need a really good question. And I feel like we've answered all of these. How about 157? You haven't answered either question about when an employee quits or if the sick time balance is printed on the check. Let's do the first one. What happens if an employee quits and they've got paid sick leave that they never used?
No obligation to pay it out.
Yeah, disappears.
Yep.
And regarding whether you have to print the sick time balance on a pay stub, what do you guys say about that?
So the statute says it refers back to the sick leave statute refers back to a statute that says when you pay your employees, you need to show employees on their paycheck or whatever, the amount of straight time hours that they're getting paid, the amount of overtime they're getting paid, their deductions, all that stuff that we would traditionally think of as a pay stub. A lot of employers do that electronically, right? They provide, with the employee's consent, you're allowed to do that electronically. So on that document or electronic system that you have, that's where the DOL says you have to track or keep a record of, paid time off or sick leave that employees have accrued and used. So whether you do that by a paper pay stub or whether you do that electronically through some sort of electronic payroll system, that's where the paid sick leave law statute, that refers you back to the other statute. That's where you would want to track their time and their usage of that time.
Okay. So it's 2:01. We've done our hour. We could probably do this every month, but we won't. You can check CBIA's website. We'll probably put information about paid sick leave up there every so often. We'll keep doing Q&As and put that on our website. Again, look at the Labor Department link. There's lots of really useful information on there. They've got lots of FAQs on there. Make sure that you're looking at the information for the paid sick leave law that went into effect in 2025. Because on their website, they have information about the law that's in effect today. They have to, because it's in effect today. Scroll down a little bit and you'll get to the information about the law that goes into effect in 2025. If you're a CBIA member, you can contact me with questions. And Nick, I'm losing my voice. This is good that we hit the end. Nick and Vincent are happy to be your lawyers if you'd like to retain them, to have them go over your policies and give you some advice on paid sick leave. So give them a shout. And until our next webinar, everybody have a great afternoon and have a great holiday. If I don't talk to you guys, thank you for joining us.
Thanks. Thank you.
Thanks. Bye, everyone.
Bye.